Hello, everybody. Welcome to Deloitte's Debriefs Tax Webcast series in Asia Pacific. Our webcast today is from our special edition Geography Update series and is titled Secondment Arrangements, Recent Rulings and Key Impact. My name is Sumit Hemkar and I'm a tax partner based in Deloitte, India. I have the pleasure of hosting today's webcast and I'm joined by three speakers today, K. Bhaskar, Aarti Raote and Suchint Majumdar. They are all tax partners based in Deloitte, India. Bhaskar is a specialist in indirect taxes. Aarti is a specialist in employment taxes and also in immigration related matters. And finally, Suchint is a specialist in transfer pricing. If you'd like to see a little or read a little bit more about our bios, these will be available on the left side of the screen. And before we introduce the agenda for today's webcast, we'd like to take a moment to highlight some of the features of our webcast console that you see online. First of all users are on listen-only mode. If you have any content-related questions, you can submit at any time in the Q&A box at the bottom right of the screen. We'll try and do our best to respond to your questions during the presentation. Secondly, all PC users can maximize or minimize each box at your convenience during the webcast. You may also explore the icons at the bottom of the screen. If you want to download today's slides and related publications, please go to the Downloads and Links box. Mobile device users can view the slides and answer the survey on the screen. Thirdly, if you require an attendance record of this event, you can download your CPE certificate by clicking Request CPE icon on the left-hand side of the webcast console. Right then, with the administrative matters out of the way, let's dive into today's topic. We have this eminent panel of speakers to talk through the recent Indian Supreme Court ruling in the case of Northern Operating Systems Private Limited. I'm sure all of you would have gone through the ruling or at least heard about the ruling. The case assumes significance since it deals with the already controversial topic of secondment of expatriates. While the case relates to facts pertinent to the period when service tax regime applied to India, but as is the case with any Supreme Court ruling, this one too promises to have a bearing on GST, income tax, maybe even other allied laws. We've had a number of cases where courts have made conclusions regarding secondment arrangements. So this case adds to the body of varying judicial literature available on this topic. This leaves for businesses an intense amount of work to be done while preparing for a secondment or designing a secondment policy at your organization. So in today's session, we have carefully selected the areas to cover. First, we will have Bhaskar take us through the key facts and observations from the current case, and of course, the significance of the employer-employee tests. We will then deal with some of the corporate and international tax related dimensions, followed by a very interesting perspective from Aarti on the concept of economic employment, followed with a transfer pricing view on such secondments along with Suchint. We will top this up with a way forward conversation from the speakers, and then we will get into our last part, which is the Q&A. We will have some polling questions during the course of the session, so please do keep a watch out for those and do participate in those polling questions. With that, I'll invite Bhaskar to take us through the key facts and observations from the current case. Bhaskar, over to you.
Yeah, thanks, Sumit, for a quick introduction and setting the context. Recently, the Supreme Court, the Apex Court of India, has passed a landmark judgment on the taxability of reimbursement under secondment contracts, and in the case of Northern Operating Systems Private Limited. Before we really come to the issue at hand, it is important to understand the legal framework around the taxability of such secondment contracts in India. From a taxability point of view, there have been three sets of legal provisions which have been applicable in the last decade, that is the period prior to July 2012, period post July 2012, and July 2017 onwards. Prior to July 2012, only the specified services were taxable in India. Thus, in case of secondment contracts, the services provided by a manpower recruitment or supply agency was taxable in India. With the introduction of negative list-based service tax from July 2012 onwards, all services were taxable in India except those specifically excluded. And again, services provided by employees during the course of employment were specifically excluded from the ambit of service tax. Thus, during the period July 2012 to June 2017, secondment contracts were outside the service tax net in cases where it was held that there is an employer-employee relationship between seconded employee and the Indian company. Position under GST regime is also similar to the negative list-based service tax regime. All supplies are liable to GST except those expressly exempted. And in the context of secondment contracts, services provided by an employee to employer during the course of employment is outside the GST net as well. As the negative list service tax regime is similar to GST regime, the taxpayers in India continued with the same position as the one taken under the service tax regime. Keeping this context in mind, it becomes quite important to understand the typical secondment arrangement and the positions followed till the Supreme Court ruling was pronounced in May 2022. In a typical cross-border secondment, the employees of the overseas company are seconded to India for a limited duration. During the tenure of the secondment, the employees work under the control and supervision of an Indian company or the Indian company. The salary is paid by the Indian company with the provident fund contributions in India. The Indian income tax is also paid and relevant forms are issued. To the extent of social security benefits paid outside India to a secondee from a continuity perspective, the Indian companies reimburse the overseas company. Again, keeping this in mind, various courts and tribunals in India have taken a view that there is no supply of manpower by a manpower supplier or a recruitment agency, as the overseas company is not engaged in the provision of such service. Again, it was also held that the seconded employees work as employees of Indian company, and since there existed an employer-employee relationship, the same would be outside the service tax net, and reimbursements made to the overseas company only from a social security perspective. The amounts which are paid outside India, in some cases, even reimbursements for salary paid outside India would not be taxable in India rather. With these favorable judgments being followed in plethora of subsequent judgments, the position of non-taxability of reimbursement under secondment contract had largely settled in India. To the extent of taxability of employer-employee transaction, the GST law is also similar to the erstwhile service tax law in India, which was applicable till July 2017. The taxpayers continued with the same position under the GST regime as well. However, the Supreme Court, in its recent judgment in the case of Northern Operating Systems Private Limited, has perhaps unsettled the settled position, and after detailed examination of the facts, the documents and record, it has held that the reimbursements made by the Indian taxpayer to the overseas company for the salary or towards the salary of the seconded employee under the secondment arrangement would be taxable in India. The principle laid down here may have far-reaching consequences and also would necessitate the requirement to revisit all the secondment arrangement. Now let us look at the arrangement between the overseas entity, the Indian company, and the seconded employees. When required, the Indian company requests the group companies for managerial and technical personnel to assist in its business, and accordingly the employee is selected with the group company and are transferred to the applicants or the appellants. The employees continue to be on the payroll of the overseas company only from a social security purposes. The Indian company issues a letter of employment to the seconded employee. The seconded employee acts in accordance with the instructions and directions of the Indian company, and the seconded employee also devotes his or her entire time and work to the Indian employee. As I mentioned earlier, the prescribed forms under the income tax is issued to the seconded employee, And again, the employees on the other hand also file their income tax returns in India and also contribute to the provident fund as well. Can we move on to the next slide? Now coming to the brief facts of the case in hand. Northern operating in India, the Indian taxpayer had entered into a contract with its overseas group company, Northern operating overseas. And in terms of the agreement, the Indian company was engaged in providing back office support services to the overseas companies. The overseas company paid the consideration to the Indian company for the services it provided on a cost plus markup basis. And typically, we all know the ITS companies work on a cost plus markup basis. The seconded employee worked under the control of the Indian company during the secondment tenure, and the Indian company was not empowered or enabled to impose any sanctions like reduction in salary or change in the terms of the employment contract. One other important factor is that the Indian company did not have the right to terminate the employment. However, the Indian company had the right to terminate the secondment arrangement. Similarly, the employee had the discretion to return, go back to the home company, or the employee had the right to terminate the arrangement as well. The employees who were seconded to India would receive their salary, bonus, social benefits, the out-of-pocket expenses and other expenses from the group company, and the overseas group company shall raise a debit note on the Indian company to recover expenses of salary, bonus, etc. And the Indian company shall reimburse the group company for all these expenses without any markup on a cost-to-cost basis. Upon completion of the secondment period, the seconded employees return back to their original position, or they are deployed elsewhere as part of the global policy. And since the seconded employee works under the direct control and supervision of the Indian company, the Indian company is responsible or is made responsible for the work done by the seconded employee during the secondment arrangement, and the overseas employer is completely absolved of any liability during such period. The letter of understanding issued to the employee also state that the deputation is for a limited duration assignment, and typically we see a limited duration assignment or a clause for a duration in all of the secondment agreements. Again, as I mentioned just now, the income tax has been paid by the secondee, and the secondee has also contributed to the PF as well in India. The letter of understanding which was issued by the Indian company to the seconded employee clearly details the salary package along with the allowances and are expressed in foreign currency and not in Indian rupees, and the salary has been decided as per the global policy. The other fact which got a lot of emphasis by the Supreme Court is that the nature of salary and the allowances paid show that the seconded employees are of a certain skill and possess the expertise which the taxpayer requires. Now let us move on to the contentions of the revenue authorities. If you just look at the revenue's contention or the tax administrator's contention is, the revenue authorities argued that the transaction would be liable to service tax in India as there was no contract of service, rather than the present case is that of contract for service. The secondment contract was essential for providing the back office support services by the Indian company to the overseas company. Overseas company provided service through its employees, and services directly pertain to discharge of function of the Indian company. So the Indian company wanted some specific skill set. They identify the skill set from the overseas company. Overseas company deputed the people to the Indian company, and the Indian company, with the help of these people, have delivered the back office services, which is part of the larger agreement between the two companies. The Indian company was not free in terms of the performance of work assigned to it by the overseas company. The Indian company was not free. They were bound by the description of the specification provided by the overseas company. The consideration was paid on a cost plus markup basis, and cost paid included the cost of salary of the seconded employees as well. The employees were working under the operational control of the Indian company, but however, the revenue contended or argued that it was only for a limited period. And this arrangement was essential, as without the control, the Indian company could not have delivered the services. Again, the revenue contended that the temporary control did not take away the fact that the real employer was the overseas company. This is the important thing. Despite Indian company having a control on the seconded employee, the revenue authorities argued that the control was only for a temporary period. The salary, the allowances, and the duration of the secondment was all determined by the overseas company. And as I mentioned, the employees reverted back to the original position and they did not remain as an employee of the Indian company, is what is the argument of the revenue. And after reading all the documents, the revenue authorities felt that this was a contract for service and not a contract of service. Looking at the taxpayers' contention, the overseas company was not in the business of manpower supply. As I mentioned earlier, prior to 2012, only services provided by a manpower supply or recruitment agency was taxable. The taxpayers' contention here was the overseas company was not in the business of manpower supply, so it should not be subject to service tax. The seconded employees are contractually hired as the Indian company's employee. They are at par with the Indian company's employee, and control over them is exercised by the Indian company. And the employees completely devote all their time and efforts under the direction of the Indian company, and the remuneration is also fixed by the Indian company. The employees were seconded to India and they were asked to report to the Indian company's designated offices. As I mentioned, as we were just discussing, they were accountable for their performance to the Indian company, and services by employees to their employers was never subject to service tax, was the argument. And only the process of disbursal of salaries and allowances is solely from an operational convenience perspective, and to have a continuation of the social security benefits as well. There are certain High Court judgments which held that service tax is not applicable on reimbursement, and the taxpayer also placed reliance on the same. And the taxpayer's contention was that the Indian company was only reimbursing the salary on a cost-to-cost basis, and that should not be liable to service tax in India.
Bhaskar, you mentioned that there are these High Court judgments in favor of taxpayers. Maybe if you could walk us through a few of them, that'll be useful for our participants.
Yeah, sure, Sumit. In the matter of Volkswagen, the tribunal held that there was an employer-employee relationship. As we are discussing, if somebody can demonstrate that there existed an employer-employee relationship, there is no service tax nor GST. Hence, there was no manpower supply services. It was held in the matter of Volkswagen. And if you just look at some of the key facts in the matter of Volkswagen is, the seconded employee worked under the control and supervision of the company. The Indian company had the right to terminate the services of the seconded employee, and the employee was in a personal capacity, and salary was decided by the Indian company. And to the extent of salary paid by the overseas company, the same was reimbursed again on a cost-to-cost basis. Again, similarly, in the matter of Computer Science Corporation, it was held that the service tax were not provided by the manpower supply company and not subject to service tax. The position regarding non-taxability of secondment contract was largely settled under the service tax, again because of favorable rulings, and these favorable rulings were also followed in the subsequent cases as well till the Supreme Court judgment. Now we can move on to the tribunal's favorable ruling in the Northern Operating India's own case. We had the favorable ruling in the matter of Volkswagen, Computer Science Corporation, and similarly we have a favorable ruling in the Northern Operating Owns case. Here, before the matter came up for hearing before the Supreme Court, the tribunal had relied on the earlier favorable rulings and passed an order in favor of the India company, which is the Northern India company, on the basis that only services provided by a manpower recruitment or supply agency were taxable in India. And obviously, the Northern Overseas entity was not in the business of providing any manpower supply services. And again, the seconded employees were working in the capacity of employees. Salary was received from the overseas company only from an operational convenience or a disbursement purposes. And since there existed an employer-employee relationship, there should not be any service tax. The taxes were also deducted and paid in India. As I mentioned, contribution to PF was also made. Additionally, contributions were made towards social security outside India. And since it's only a reimbursement of salary made by the Indian company to the overseas company, it was held that it's not taxable in India. So this is the tribunal's order in the matter of Northern Operating, against which the department has gone before the appeal before the Supreme Court. Again, one point to note here, Sumit, is the question of facts are decided by the tribunal, and Supreme Court typically rules on questions of law. However, in the present case, to pass an order on the question of law, the Supreme Court of India got into detailed analysis of the facts and underlying documentation. Moving on to the next slide, the Apex Court, before providing its ruling, went through these aspects. I just wanted to narrate few of them. The court observed that the crux of the issue is to identify who is the employer to determine whether it is a contract for service or a contract of service. Mere fact that the Indian company exercised control during the duration of the secondment contract is not sufficient to determine whether there is an employment arrangement between the employer and employee. Again, the Supreme Court also discussed, saying nomenclature of the document is not determinative of its nature. And a very important discussion or a finding is the Supreme Court wanted to or laid emphasis on seeing the substance versus form in all of this kind of a thing. And the court also observed that it has to discern the true nature of relationship after taking into account all the documents on record. If you go to the next slide, keeping all these aspects in mind, the Supreme Court held that the reimbursement of salary made by the Indian company to the overseas company under a secondment arrangement would be taxable in India, as the employees continue to be on the payroll of the overseas company. The overseas company's employees are seconded for a limited duration, and post their duration, they return back to the original employer, understandably. And they are not treated as employees of the Indian company post the cessation of secondment arrangement. Again, the salary package and the allowances are quoted in foreign currency, and the salary and the terms of employment are also as per the policy of the overseas company. The salary is also paid by the overseas companies in this case. Overseas company had a pool of resources who are seconded on a need basis, and this overseas company deploys them under a secondment arrangement which is in relation to its business. Again, if you just recall, I said the Northern India company is providing a ITS kind of a back office support services. For providing that, they require certain skill set, and the skill sets have been imported from the overseas company. So Supreme Court is of the view that there is a quid pro quo between the Indian company as well as the overseas company. Keeping all this in mind, the Supreme Court has held that the reimbursement for the salary cost made by the Indian company to the overseas company would be taxable in India.
Thank you, Bhaskar, for this pointed and very elaborate discussion. That brings us to the first polling question of the day. And the question is, this should be flashing on your screens now. Does your company have secondment arrangements with Indian companies? And your options are, first, yes, already have secondment arrangements. Second, planning to enter into secondment arrangements. Third, no, not envisioned at this time. And fourth, don't know, not applicable. We request you to kindly make your selection for the poll that's showing on your screen. And while we wait for the poll to complete and the results to come in, Bhaskar, one question that came up in my mind at least, and this is you can respond it quickly. You mentioned that secondments were almost, the issues were settled before the Supreme Court ruling came in. So now what happens to cases where taxpayers have favorable orders from the tax authorities? Can the authorities open these cases once again?
Yeah, thanks, Sumit. It's a very good question. I think we have enough judicial precedents to say that once the case has attained finality, basis of Supreme Court ruling, the cases should not be reopened. So we have a good amount of judicial precedents, and the taxpayers can rely on that. I think that is something which one of the things which I said is we need to just make sure that the case. I'm only talking about those cases which have attained finality. However, for those cases which are pending adjudication or it's in the it's in the appellate forum. One has to just see the impact of the apex court ruling, and it's, as you know, the apex court ruling is the law of the land. So at least for the cases which have reached finality, we have judicial precedents to say that it should not be reopened.
Thank you, Bhaskar. We also have in the meanwhile the results of the first poll, and seems like a reasonably divided house here. A large number of our participants say that they already have secondment arrangements. Some say that there aren't any envisioned at this time, and some are also in the category of not applicable. And there are a handful, maybe a few, who are also planning to enter into secondment arrangement. So that gives us a landscape of, yeah, this is a sort of a divided question in that sense. But mostly we found in multinational situations that there are secondments that are envisioned for better operation of the business. All right, so that maybe helps us get on to our first segue from the case, and maybe I can talk through some of the relevant corporate and international tax issues emerging from the observations in this case. And we all know that in this era of global commercial mobility, employee secondments become a key initiative for most companies, especially multinationals, as I mentioned. And it's an effective way of collaboration through mutual understanding. So what you see on the slide is a few items which we've listed down, which represent some issues that may arise on account of secondment of employees into India. Now, before we get into some of these specific matters, there are various shades to secondments, and most of us might be aware. But just for a recap of the understanding around it, first of all, they could be determined on the basis of the term. They could be long-term, medium-term, short-term. There could be a payroll-based determination that whether the payroll shifts or it does not shift, stays with the home country, shifts to the host country. There could be also differentiations on the basis of the functional profile that is performed by the expatriates, whether they are performing a core function, whether they are performing a support function, whether they are client-facing, whether they are non-client-facing. The social security is an important HR dimension to the whole equation. Employment taxes become a very intense personal issue for the individuals. And of course, for companies, the corporate tax issues also become significantly critical and important. Now, all of this variability gives rise to some very interesting issues like permanent establishment for the business entities, withholding taxes on a multiple set of transactions, payroll determination, employer-employee relationship determination. And over the years, there have been various arrangements, modalities that companies and businesses have established and have been working through, with them, and with various degrees of distinction. So while in a typical secondment arrangement, you'd find that part of the salary is processed by the entity to whom the individual is directly seconded. And such entity would typically also undertake the regular statutory compliances relating to the employment of the individual, also income tax compliance potentially. This is mainly done to make sure that all compliances which are more clearly known, available, with the local entity, that is easily determined and settled with the regulators. Almost parallelly, even in such situations, there are continuing arrangements with the overseas entity, typically in a situation like this, and that is essentially to ensure that there is continuity of the social security benefits of the secondee. Now, processing of the payroll also happens at the overseas entity level typically, and there is participation in evaluation. There is an effective right of termination of the contract. There is some level of you can say control over the employee. So all of these kind of throw up variations which can result in some fine shades of distinction in how the consequences could apply. Now, under income tax, in the past, we've had several court precedents where courts have had the they've reviewed complex secondment arrangements, and they've carefully looked at clauses in various contracts as well. And even the Supreme Court in the past has laid emphasis on some of the tests, such as the celebrated in the Morgan Stanley case. There was a test, there was a stress on the lien on employment, for the employee, and also in the Eli Lilly case. What we see is that there has been a consistent recognition of the concept of legal versus economic employer as well, as per the jurisprudence available under income tax. And language and terms contained in the main and supporting documentation tend to become an important ingredient for reaching a conclusion in a particular facts of a particular case. The conduct of the parties are sometimes also delved into. Sometimes, we found that in cases of surveys, incriminating documentation has been found at the premises of a particular business entity, and that kind of creates more ability for the revenue to be able to really get into the substance of the arrangement and not follow only the form. So conceptually, you could have an employment with the local entity as one scenario, and as a second scenario, you could have a resulting employment only with the foreign entity. Of course, you could have situations of dual employment as well. But if it was the local entity, then I think pretty much cases are sorted, because the going in presumption for typically secondment arrangements is that you'll be able to establish employment at the local level. But for where that is not possible to be bridged because of maybe some limiting factors or facts that are available on record, then you have issues like permanent establishment, tax withholding, maybe potentially transfer pricing. So all of that gives rise to difficulty in reaching a clear conclusion around the implications. Now, the reimbursement of the salary cost in most cases where the employment is with the overseas entity or held to be with the overseas entity, that reimbursement poses an important question: that is there a tax withholding that is applicable on that? And we all know that fees for technical services is an important determination or criteria for assessing whether there could be a gross basis of withholding, or if because India's most of India's tax treaty, or at least some of the significant ones, have a service fee clause as well. Therefore, there could be a possibility of a permanent establishment also to be found in India, and service fee is not the only one that can be applied. It could be a fixed place fee as well, and that could lead to more complications, because then you're not following the gross basis of withholding, but you're also looking at potentially an alternate way of taxing, which is the net income basis of taxation, and that leads to the big question and subjective question around attribution of profits and maybe the transfer pricing analysis around that. Sometimes we've also seen that, with the presence of an overseas employee in India, overseas entities employee in India, you could potentially have an exchange control registration requirement, which is in the form of a place of business, registering a place of business by the foreign entity in India. So all in all, the resulting consequences could be for the foreign entity maybe seeking some tax registrations in India and making some compliance filings in India. Of course, on the salary side, we'll get into more discussion through our discussion with Aarti, and on the transfer pricing side, we'll get into a more detailed examination through our conversation with Suchint. So overall, in conclusion, I would say that there is no magic formula, unfortunately, to determine which factor could be the most material factor in determining the employment. Where does the employment of the employee lie? And therefore, I think the focus, of any person who's looking at a secondment or devising a secondment policy would be to take a well-coordinated approach within the, by looking at a confluence of, knowledge around indirect taxes, income taxes, employment taxes, immigration laws, and also transfer pricing, so that there is a better coherent outcome that can be achieved based on the particular facts of the case. So with that, let me turn to and invite Aarti into this conversation. Aarti, with all that we've heard from Bhaskar, and given that the employee perspectives become so central in this whole exercise, what are your key observations from the Supreme Court judgment, and how do you think that impacts businesses, especially in context of the theory of economic employer that we referred to right at the beginning?
Right, Sumit. The test of any proposition is based on two basic aspects. One is the substance and the other is the form. So when we look at the substance, the question that the Supreme Court has examined is, who is the employer for the seconded employees? And courts in this, in the past have held that the relationship between parties to a contract of employment is governed by the express and implied terms between the parties, and also the statutory rules governing it. They cannot be excluded. So these could be something like rules around unfair dismissal or redundancy, or health and safety at work, or trade union memberships. All of these do matter. An employer has been defined as a person who has direct control and supervision on the employees, and who directs how the work is to be done. The employer receives the benefit arising from the employee's work and constitutes inseparable part of the employer's business. And it is therefore he who bears the risk and reward of the employee's work. The employer is also responsible for reviewing and appraising the work performance and determining the remuneration. And these are the principles that are helpful in determining the true essence of the arrangement, as to whether the same is the contract for service, or it is a secondment, or it is a contract of service. While for a direct employment, a direct hire, these tests are easily satisfied because the matter is between two people, the employer and the employee. But this matter becomes very complex in case of secondment arrangements because there are two employers involved. One is the legal employer and the other is the economic employer. Recognizing this challenge, the OECD has provided some guidance on the factors that are determinative of economic employer. Other than the nature of work of the individual and the authority that he exercises while executing his work, the economic employer is the one who has an authority to instruct the individual as to how the work is to be done, who controls and has the responsibility of the place at which the work is to be performed. The remuneration of the individuals is directly charged by the formal employer to the enterprise to which services are provided. Now, one thing to be noted here is that the OECD recognizes that there is a formal employer who is responsible for paying the remuneration, and that is charged to the person who is the recipient of these services, which is the economic employer. It is not said that the economic employer has to pay the salary, and this is a fine distinction which the OECD has brought. The other factors that are determinant are that who is the person who provides the tools and the necessary materials to execute the work of the individual, who determines the qualifications of the people who are supposed to do the work. An economic employer will also determine how many people they need. They will select the right individual, and they will also have the power to terminate that contractual arrangement. Now, it is termination of contractual arrangement and not necessarily termination of employment as such of that individual. So this is also a factor that is different from what the OECD guidelines suggest as compared to what the Supreme Court has kind of determined in their decision. An economic employer also is the one who could impose disciplinary sanctions, who would have the operational rules like holidays, work schedule, office timings. All of those are determined by the economic employer because he is responsible for the place of work. So it is observed that all these conditions which are work related are met by most companies, and in most secondment arrangements, this is agreed upon by the employee and the economic employer. But as alluded to by Bhaskar earlier, in most cases of secondment, the remuneration payment is practically continued overseas to ensure continuation of social security in the home country of the expatriate. Or it could be a personal choice of the expatriate also. This effectively means that there is a close nexus which is established between the home entity and the employee. The Indian courts rulings have primarily focused on this aspect of contractual relationship. In the instant case as well as the previous judgments, the judges have raised a very powerful question as to who has the responsibility to pay remuneration. That is, if the remuneration payment is not made, then whom does the employer really look up to or sue? Is it the Indian employer or the overseas employer? The observation made by the court in this order is that, and I quote here, it is doubtful whether without the comfort of this assurance, employees would agree to the secondment. And in reality, the secondment is a part of the global policy. In fact, the court also observed that the terms of employment were in line with the policy of the overseas company rather than the Indian company. And this is actually different from the fact on the ground where an Indian employment letter was actually issued. So this is one of the factors which the Supreme Court has laid emphasis on. The second factor which courts have laid emphasis on is the determination that the employee had a lien over the employment. In most cases, the employee has a choice to terminate the assignment early and return to the home country, and they are assured of reinstatement in the home country entity. The Supreme Court in this decision has disregarded the importance of control test and concluded that it's not really determinative of who the employer is, and placed heavy reliance on the fact that the salary continued overseas, it was in foreign currency, and the employees are reinstated with the overseas entity at the end of the assignment. So this decision, in my view, takes a very narrow view of secondments to determine who is the real employer and disregards the globally accepted principle of economic employer, which is why there are several contrary judgments indicating that that secondments are not really a manpower supply contract or a service contract. And so as Bhaskar called out earlier in this session, that this decision actually unsettles the more or less settled position of secondments.
Thank you, Aarti, for that. Can you tell me what changes post this decision for Indian employers? Do you perceive a change?
Well, in the current situation, as of today, what happens is that the Indian employer in all aspects projects itself to be the employer of the deputed individual. For example, in the immigration documents, for payroll compliances, issuance of Form 16, in all these cases, it projects itself as being the employer of the seconded individuals as far as the secondment period is concerned. Now, if one can probably argue that if the arrangement is determined to be a manpower supply contract, then would the overseas company now be burdened with all these compliances? It's possible for the overseas company to comply with these requirements, but it would also be actually quite burdensome to do it for a handful of people only. The documentation also would need some change to reflect this relationship between parties. And it's observed that foreign companies generally comply with employee compliances in India when the employees are sent on projects to client establishment, where there is no nexus or no link as such. But in case of a secondment, the Indian company always assumes the role of the Indian employer. So it may be noted that as a part of the arrangement, the employees are also equalized, and the taxes are deposited to the tax authorities through a shadow payroll mechanism by the Indian company. There are also some other benefits like accommodation, car, chauffeur that are provided by the Indian employer to the employee. So as such, one can argue that a part of salary is actually paid and borne by the Indian entity also, and hence it has to be considered as an employer too. And hence, post this decision, I would say that the Indian entity can continue with the payroll responsibility as a choice exercised by the employee. And of course, since the employee is working in India, rendering services in India, they also have an obligation to file tax returns in India. So in all probability, there's no immediate change which is envisaged here.
Thank you, Aarti. Quickly, can you talk our participants through the typical documentation that you think is almost necessary in a typical secondment arrangement?
Right, Sumit. In a typical secondment arrangement, there is a secondment agreement which determines the broad terms of the seconded employees. It would have an clauses which covers the relationship between the two entities, captures terms and conditions under which employees could be seconded, with the right of selection, control on the employees, who has the right of termination, process of cross-charge, roles and responsibilities of either entities. These are some of the aspects which are covered in the secondment agreement. The second document which is essential is an assignment letter, which is issued by the home country entity informing the employee of the assignment in India, the general terms, deputation period, nature of activities, remuneration, facilities, insurances that could be extended over the period. There's also a letter from the employee, in some cases, requesting that the salary be continued overseas to continue with the social security requirements overseas. That's a request made by the employee. The next important document is the India offer cum employment letter, which actually provides the employment relation between the employee and the Indian company. And this letter would have the normal clauses as are observed in any Indian employment letter, which is the rules and regulations, the policies that they have to abide by, the remuneration, the coverage for taxes and provident fund. Basis this, the Indian entity assumes the role of the employer and proceeds to comply with the tax and all the allied laws for the expatriate. The issuance of immigration letters, invite letters, guarantee letters, registration with FRRO, Form 16, or registration for PF, wherever applicable, would all follow basis the single premise that Indian entity is the employer. And last but not the least, there would be regular debit notes which would be raised through the year on the Indian company to cross-charge the remuneration cost. It is ideal or it is advisable, I would say, to be having processes in place to document HR and talent related aspects of appraisal, discussions around remuneration of the employees, as is the case with regular employees. So typically we see these documents, Sumit.
Thank you, Aarti, for that. And now turning over to transfer pricing, and let me invite Suchint. Suchint, what would you say are the transfer pricing ramifications of this decision?
Thank you, Sumit. Taking a view of the impugned arrangement, let us consider the following intercompany transactions. One is to do with the secondment of the employees by the overseas entity to the Indian company. The second is the provision of administrative services by the overseas entity of managing the retirals and benefits from overseas when they are on deputation to India. The third is the cross-charge of the compensation that is paid by the overseas entity and reimbursed by the Indian entity. That takes the nature of a reimbursement. The fourth is the intercompany services that are provided by the Indian company, of which the reimbursements and related costs forms a part. And this is on a cost plus markup basis normally. And finally, there is the transfer of employees when they return back to their associated enterprise or their home base, or maybe deputed elsewhere. Now, while the intervening transactions have been dealt with by the apex court, it is useful to focus on the consideration for the transfer, which is being taken by the decision to be the running compensation of the seconded employees. Now, the OECD guidelines and indeed Indian transfer pricing regulations contemplate the transfer of trained assembled workforce or employment agreements to be an intangible, in other words, a human capital related intangible, warranting an arm's length compensation. The question therefore does arise as to whether in an unrelated party context, the release of personnel from the overseas entity would have triggered a compensation, such as an exit charge, that represents the monetized value of skills or capabilities that are being transferred from the overseas to the Indian entity. Then the basis of consideration for the secondment would be this transfer price, which has been paid for the secondment, which then allows the Indian entity to become the economic owner of the intangible, which is the assembled workforce comprising the deputed personnel. Therefore, the transfer pricing implications go beyond the intercompany cross charges, and to the point about the OECD guidance that Aarti referred to earlier, a release of employees on secondment by way of compensation towards the secondment would enable the Indian company to be the economic owner of such intangibles. So much so that when the employment is over and the employee is repatriated to another entity, there would have to be a corresponding compensation to the Indian company on that event. Now, that said, it is true that all the costs of the seconded employee should form part of the cost base of the Indian company upon secondment. So, the retirals or employee stock option plans that the overseas entity extends to the seconded personnel should be reckoned in the cost base of the Indian company, assuming that the Indian company is operating on a cost plus basis relative to the associated enterprise. And therefore, this will be reckoned for applying a markup on operating costs, such that the Indian entity recovers its consideration being the full cost of all the amounts it has expended, plus a markup thereon. And importantly, a markup on amounts that it has not expended but would have imposed had it incurred the cost itself. In other words, any forms of free of cost services or free of cost retirement benefits from the that may be provided by the overseas entity, not cross-charged to the Indian company, would also have to be reckoned for the purpose of markup. Therefore, at the core, we do have to be mindful of the interplay between intangibles and services. What may appear like a service contract could, as in the present case, be a transfer of intangibles and the service emanating from such intangibles transfer. And as a result, could be reckoned or viewed as separate transactions, referred to as identifying the real deal. We are often confronted with deemed international transactions where there is an overseas entity, uh, in other words, there's a global transaction and that has an Indian footprint. And the entire business of a corporation under such arrangement is transferred. And there is therefore the transfer of both tangibles and intangibles at an India level. And it requires the third party that is acquiring such intangibles at an India level to compensate the transferor entity at arm's length. What is also something to consider is the consideration if the foreign entity is regarded as the employer and it results in the creation of a permanent establishment in India. That can bring up not just fundamental attribution aspects, but also cause reporting and disclosure obligations. So think of country by country reporting, pillar two, and that means that we have a piquant situation here between indirect tax and international tax positions. Back to you, Sumit.
Thank you, Sachin, for that very interesting perspective on the associated transfer pricing issues with secondments. Clearly, something to think about for all our participants. And that brings us to the second polling question of the day. The question is right on your screens now. Whether the employees seconded in your organization are employed as per the global employment terms or as per terms applicable to a regular Indian employee, including the remuneration policy. And your options are global employment terms and second, Indian employment terms. Request you to kindly make your selection in the poll that's showing on your screen. And while we await the completion of the poll and the results to come in, Aarti, maybe if I can turn back to you, and if you can tell us a little bit more about, and quickly maybe, the impact of PF where, overseas entity is treated as an employer.
That's a tricky question, Sumit. PF is applicable to establishments where there are more than 20 employees hired. And if the overseas employer has less than 20 employees in India, then for the sake of argument, one can say that PF regulation really does not apply to these employees. However, I may caution you that there are several rulings and several positions taken by the PF authorities where overseas employees and technicians have been counted as a part of the Indian establishment for the purpose of applying PF regulations. And this is because the workplace is in India and hence PF would apply. I would say the matter is not beyond doubt here.
Sure. Thank you for that input, Aarti. And we do have the results of the poll, and I think a large number of the participants are agreeing that they have their secondments are typically structured on global employment terms and not on Indian employment terms. Although I'm a little surprised by the number of participants saying that their secondments are as per the Indian secondment terms, which is a helpful factor, I would say, given the observations that have come out from the Supreme Court in the Northern operating case. So some work to be done, I would say, still for some of us. And that kind of brings us to the end of the second poll as well. And maybe now let me invite Aarti, Bhaskar, and Suchint, all three of them, to talk us through what is the way forward for businesses, because we've heard of issues that Bhaskar described. We've heard of income tax, employment tax, immigration related matters, transfer pricing issues, and I'm sure our participants are now with a set of ideas or maybe some confusing factors around what should be the way forward and how should companies and businesses be thinking about how to structure their secondment. So maybe we can start with you, Aarti, first, followed with Bhaskar, and then finally Suchint.
Sure, Sumit. I would say the starting point here is to review the arrangement to assess what is your current situation and to align the facts on the ground with the documentation that you have. This would obviously involve examining the roles and responsibilities of the individual and realigning them with the available jurisprudence. A lot of times we observe that there are minute things like description on debit notes, reporting of remuneration in Form 16, or reconciliation of cross charges, which is not correctly done. And this raises questions at the time of assessments. Hence, one needs to take a very holistic decision considering all the direct and indirect tax aspects and relook into the substance as well as the form of the transaction. That would be my input. And over to you, Bhaskar, for your comments.
Yeah, so thanks, Aarti. I think I completely align with what you said in terms of revisiting the writings between the companies. That is one. And Sumit, Aarti, one of the things which I would suggest is one, at least going forward from the current date till going forward, if the companies can recover the GST payable either in terms of the credit or in terms of the refund, I think the company should seriously consider just paying this up and then recovering the input tax credit or the refund, of course, subject to keeping other consideration in mind. And at least for the past period, as I alluded earlier, we need to handle this with different set of gloves, at least for those matters which have attained finality and the ones which are in the process of getting adjudicated. Our sense is, from a GST perspective, if businesses can recover the tax credit and also or claim a refund, they being an exporter of services, businesses should strongly consider payment of GST and recover the same.
Yeah, in addition to what Aarti and Bhaskar mentioned, identifying each of the relevant transactions and transfer pricing each of them. That's not to say that they cannot be aggregated or intentionally set off. However, calling them out in the transfer pricing documentation and disclosure forms is essential. So also is the determination of all the costs that go into the cost base for the provision of services. Now, this is another area of controversy, and there is exchange of information or common data points. For example, all that goes into the determination of the base of the transaction for reverse charge is also what has to be reckoned for the computation of the cost base for transfer pricing purposes if it's on a markup basis. And then finally, the implications of service PE exposure give rise to attribution of profit aspects for the overseas entity. Thank you, Sumi.
Right. Thank you, Suchint, Bhaskar, and Aarti for that useful insight on the way forward. I think this continues to be a developing area, and I'm sure all our participants have benefited from the way forward that you outlined. So while we are maybe close to the 1 hour times allotted to us for this webcast, we have some time for a quick poll, a third poll, and this should be flashing on your screens now. The question is, what is your biggest concern in case of secondment arrangements? And your options are: first, permanent establishment risk; second, tax withholding on cross charges, treating payments as fees for technical services; third, substantiating cross charges and related documentation; fourth, indirect taxes; fifth, transfer pricing consideration; and sixth, don't know, not applicable. So request you to kindly make your selection in the poll that's showing up on your screen. And while we await the completion and the results, Suchint, maybe if I can ask you a quick question, do you see an interplay between transfer pricing for services and attribution of profits to a service fee for secondment arrangements? I mean, now that we have more guidance through the Supreme Court order.
Very relevant question, Sumit. It is pertinent to consider the view of the Apex Court in the Morgan Stanley decision referred to earlier as well, wherein it was held that if the services are compensated at arm's length, then there would be no additional profit attribution to the permanent establishment. And this is interestingly also endorsed by the draft paper on attribution of profits to the PE that was released in 2019. So I hope this helps address the question.
Right. Thank you, Suchint. And I know we are running out of time, and we also have the results from the poll as is showing on your screen. Tax withholding seems to be the key issue that businesses are facing now. I know we unfortunately don't have time for Q&A, but please do write in your questions to us, and we will take time to respond to the question that you pose in. Unfortunately, that's all that we have time for in today's discussion. Thank you all for joining us for today's session, and some quick recap around the points in the webinar. We'd encourage you to fill out a short survey that will pop up on your screens momentarily. So please give us your feedback. If you joined us late, no worries. This presentation is archived for future viewing. So, and if you think that there are others who could benefit from this webcast, please do share the link, the share this icon that's there on your screen, or you could direct them to the debriefs website. And we will, like I said, respond to all the questions submitted during the webcast. So please look out for our responses, and we'd be happy to get into a conversation with you as well. And finally, don't forget to tune into our next scheduled webcast, Global Mobility, Talent and Rewards. This is slotted for 14 July. And it's titled on Labor Codes, Update on State Rules and Overall Status. Finally, from all of us at Deloitte, thank you for your participation in this Asia Pacific Tax webcast today. Goodbye.